Hi, I'm Ana Swanson. I cover international trade for the New York Times, and I'm delighted to moderate this panel today on tariffs in an uncertain legal environment. So, this panel will be talking about one of the most interesting economic and legal battles of the moment, the Supreme Court reviewing the legality of President Trump's tariffs issued under the International Emergency Economic Powers Act, or the lovely acronym we all know as IEEPA. So earlier this year, multiple courts found that the administration had overstepped its authority under IEEPA. The president had used IEEPA to issue two big tranches of tariffs, one on Canada, Mexico, and China for their alleged role in the fentanyl trade, and also reciprocal and global tariffs against dozens of countries that were meant to address bilateral trade deficits. So I have a great panel here today to talk about both the legality and economics of these tariffs. Natasha Sarin is the president at the Budget Lab at Yale. Peter Harrell, a non-resident fellow at the American Statecraft program at the Carnegie Endowment for International Peace. Scott Lincicome, the vice president of general economics and the Stiefel Trade Policy Center at the Cato Institute, and Stan Veuger, the senior fellow in economic policy studies at the American Enterprise Institute. Thank you all for being here with me today. I'm interested to hear your remarks. So I thought I would start with just a round of sort of predictions about this legal battle that is unfolding before us. It would be great to kind of set the table here with, what is happening in the next few months and what your expectations are for how the court might rule. Natasha, I thought I would start with you. What is at stake here, and how do you see these court proceedings potentially playing out?
It's sort of hard to get into the Supreme Court prediction market just because we are in such strange and uncertain times. But I will say that sort of what's at stake feels pretty foundational from the perspective of the economy, but also from the perspective of the court. And as we think about three branches of government and their sort of co-equal stance with respect to our nation's governance, because you're dealing with a court that, especially in recent years, has been very focused on something called the major questions doctrine. And at the heart of the major questions doctrine is this idea that in areas, particularly if you think about sort of tax and spending powers, which are explicitly in the domain of Congress, in areas where Congress wanted to delegate power to the authorities, so says the major questions doctrine, it does so explicitly. But what it doesn't do, and this is actually what's very interesting about this case, and will be very interesting to see much of sort of many of the cases, frankly, the Supreme Court is considering in the coming months are turning on a pretty interesting ideological shift, potentially, because it's been a very much a conservative viewpoint. It's like former Justice Antonin Scalia was of the view that Congress wouldn't hide elephants in mouse holes. So it wouldn't be the case that we would be in a situation where if you take this particular case and you take this particular statute in IEEPA, it never mentions the word tariffs once. Over decades of use, it's never been used in the context of trying to legislate tariffs at all, let alone to trying to effectuate broad-based tariffs worth $3 trillion over the course of a decade on essentially every sector of the economy against essentially every country, ally, and adversary alike. And so if you follow that sort of where the court has been in recent history, in this view that when Congress wants to delegate authority, it does so explicitly. The answer in this case is pretty obvious. It's like that as a result of that, it's the case that this isn't a statute since 1974. It's never been used in this way. You kind of can't invent new authority with old statutes and try to find ways in which, particularly on large economic and political questions, try to find ways in which to seize executive authority. Then the court should say that these, like the courts below it have said, that these tariffs cannot stand. The reality is, I'm not sure what the court is going to say in this particular context, and something that's especially a sort of a complicating factor, and it'll be interesting to see the extent to which it comes up in oral argument and comes up as we go through and see not just the government's briefs, which have been filed, but also the reply briefs, which are coming, is how much the sort of nature of what comes next should this case come down against the administration is an interesting, it's like a hard thing, right? You have $80 billion of tariffs. Like, do they all get refunded? There are other authorities that the administration could be relying on in exactly these contexts to effectuate exactly these tariffs. They could go to Congress and say, just give us these tariffs at these levels. And so, how are we going to sort of go on from here? And how much does the court care about that type of uncertainty? And the fact that there are these other authorities in this space is an open question that I'm super interested in my co-panelists' thoughts too, but also super interested to see in the weeks ahead.
Right. Any co-panelists would want to jump in there with
Well,
yeah.
to follow a more pragmatic approach, if you look at prediction markets, predicted has the court striking down the tariffs at a little bit over 50%. Kalshi has it striking them down at a little bit over 50%. If you look at the Federal Circuit Court of Appeals, which is the one appeals court that's decided so far, and you take the share of Republicans who sided with the government there and the share of Democrats that sided with the government there, and you multiply that by the composition of the Supreme Court, you end up with a sort of slight victory for the government, but very close, or 4.75, 4.25, I don't know how, if you just want to base it purely on the partisan affiliation of the justices. I know constitutional lawyers like to think of themselves as being in a more serious business than that usually, but I think it gives you a good indication of the fact that it really is going to be close. I agree with Natasha that the major questions doctrine is the elephant in the room here. You've heard from the government in its brief, and I think Justice Kavanaugh in particular has hinted at this in a prior decision, a prior opinion, that perhaps the major questions doctrine should not carry as much weight in the foreign policy realm. Then, of course, the question becomes, are we here in a foreign policy realm? I think, as Natasha points out, the tariffs have major economic consequences that reverberate throughout the domestic economy. They affect every household, every firm. And so it's a little weird to treat that as purely a foreign policy issue. It's even stranger if you think back to what federal tax policy looked like in the early republic. If you go back to the first few decades after the founding, practically all tax revenue came from tariffs. And so to then say tariff policy is foreign policy would imply that for the first half century or so of the existence of the United States, tax policy was foreign policy. Now, if that's foreign policy, then there is really no domestic policy left. And so I think it'd be strange to extend that realm all the way to these all-encompassing tariffs.
Yeah, I think Stan and Natasha, I tend to agree with that. I think the one thing that is a bit of a challenge beyond the Article 2 and foreign affairs issues is some of the broader institutional issues for the court itself. You could kind of see the administration has a bit of a fallback plan, that is to claim that refunding the tariffs, that invalidating these tariffs would do all of these economic terribles, right? It'll cause the Great Depression, Trump said, and they put this even in their briefs. And you could see that if the court, because the court does have this tension between some of the foreign affairs and Article 2 stuff and then the clear Article 1 major questions things, you see they're trying to maybe fire off a tiebreaker of sorts to say that, hey, court, don't get involved in this. This is a political issue and it's going to have massive economic and foreign policy repercussions. So even if on the legal merits you might want to be deciding for the plaintiffs in this case, maybe find a way not to, just to for institutional reasons. And Chief Justice Roberts has very strong institutionalist views of the court. So I think that's the other elephant or so.
Yeah,
in the
to
room.
quote the opening paragraph of the government's brief: with tariffs, we are a rich nation. Without tariffs, we are a poor nation.
Yeah. Yeah, and those arguments are ridiculous, and for all sorts of reasons. And we're actually putting in a brief on a lot of those factual issues, and as an amicus. But you can see that I think that's the other big question mark here. And it does truly make it a coin toss. And I should note, we've been saying it's a coin toss. We wrote, in October of last year, we wrote a detailed briefing paper on all of the presidential tariff powers and why there needs to be reform in Congress and all that jazz. But even at that time, we said, it's a very clear split among both trade lawyers and constitutional lawyers as to where an IEEPA tariff case would come down.
Peter, do you want to jump in?
Well, maybe I'll just on this opening point, I'll go out on a little bit of a limb and open a little bit of a disagreement with my co-panelists, because I actually don't think it is a coin toss. I think the court is significantly more likely than not to strike down the tariffs. I don't think it's a 90-10 kind of call, but I think it's probably in the sort of 70% range that the court does strike down the tariffs. But I think one of the reasons that the court is relatively likely to strike down the tariffs, because I do take very much the point the court has to think about its institutional role and its institutional prerogatives. But I think one of the reasons they're more likely to strike down the tariffs is actually if they do strike down these tariffs under IEEPA, there are a whole set of statutes the court can point to in its ruling, noting that they are not saying the president does not have any delegated tariff authority. They're simply saying IEEPA is not a delegated tariff authority, and the president has to follow the processes and procedures that Congress has laid out in various other statutes. So I think it's sort of personal view is it's more likely than not, substantially more likely than not, that the court strikes down these IEEPA tariffs, but they will then see a reconstruction of some percentage of these tariffs under other authorities.
Yeah. So I would just add, the administration's already been really clear that is their plan B, and you can even see them maneuvering right now to expand the national security tariffs under Section 232 to effectively reverse engineer the IEEPA tariffs via these other mechanisms, it is kind of funny in the sense that they're doing all of this while still claiming that invalidating IEEPA as a tariff power would be this disaster, even though they're already pursuing Plan B out there in the real world.
I do also have to make one quick point on the briefing and the undermining the tariffs a disaster. Because if you read the briefings are actually very clear that they say the president believes that it would be a disaster to lose the tariffs. Notably absent, the Department of Justice is not attaching its own imprimatur to the president's belief that removing the tariffs would be a disaster.
Natasha, did you want to jump in?
And just one more sort of affirming, I think, what Peter's view is. I feel like it's useful to think about this case in the context of many other sort of important cases that the court has upcoming, where the possibility of getting yourself into some sort of constitutional crisis vis-a-vis the administration, if they make decisions that push back on some of the administration's authorities in a whole host of places, be it removal authorities, be it with respect to the National Guard, be it with respect to immigration authorities. It means that one of the things that this case has going for it, if you're the court, is the fact that those other authorities exist, right? Because it's a way to go against the administration relative to some of these other arenas, but it doesn't actually go against the administration's desired policy outcome because they have all these other tools in their toolkit. So I have wondered if a version of what Peter said is right, though I'm wary of getting away from the prediction markets, because I think we have been taught time and time again, and there's great empirical research on this, they're basically always right. But I think there is some there if you think about it in the context of what all is before the court over the course of the next few months.
I hope that y'all are right. But maybe it's just because I have too much PTSD from the previous tariff litigation where the Trump administration refused to say in the 232 litigation that peanut butter could not be a national security threat. And then they did all these wild expansions of the tariffs and the courts basically just rubber stamped it all along the way. So maybe I'm just shell shocked from all that, but I do hope y'all are right.
Well, this is the week that upholstered furniture is also getting rolled out as a national security tariff, right?
Right.
So very interesting. I wanted to know, I mean, Scott, I think you addressed this in your brief, potentially the argument that these are unique and extraordinary threats, both trade deficit and fentanyl. I'm also curious if how much the court wants to be in the position of determining what the president can say is a threat to the United States. Any thoughts on that?
Yeah, I mean, I think Stan's brief at the Federal Circuit did a great job explaining the trade deficit stuff, right? The idea that a trade deficit that we've had for 30 years that very, very few economists think is a problem at any time, but is particularly right at this exact second as some sort of national emergency, is pretty kooky economics. And then, Canadian fentanyl trafficking is equally silly. But I think, you're right that I doubt the court will want to second guess the declaration of the emergency. I think instead, where they can push back is simply the use of IEEPA to address and global tariffs to address that emergency. So, and I think that's the other thing that one of the reasons why making a prediction about this case is so difficult is there seem to be an almost infinite way for the courts to kind of half the baby somewhere in here where, maybe the Mexican fentanyl tariffs are okay, but the global reciprocal tariffs, which aren't even reciprocal, are not okay. Maybe they'll, so there's a lot of different ways that this can go without having this nice, clean ruling that we all would like.
Yeah, did others or Stan, did you want to talk about unique and extraordinary threats?
No, well, I mean, I agree with Scott's point that we explained this very well in our Federal Circuit brief. We'll organize a similar brief by economists now for the Supreme Court. The points we make there are relatively straightforward. One, the aggregate trade deficit is determined by sort of macro decisions that are made by American consumers and firms. They are not driven by sort of minor differences in trade policy. The aggregate trade deficit is also a sign of macroeconomic strength in the sense that they are the necessary counterpart of large inflows of investment into the United States. Of course, the administration wants to have it both ways. They, on the one hand, want to have a trade surplus. On the other hand, they also want large amounts of investment to flow into the country. In fact, in their brief to the Supreme Court, they emphasize how large the incoming investment flows are that they have negotiated in some of the deals or frameworks they've reached with a number of our trading partners. You cannot have both at the same time, just as a matter of accounting. That's the aggregate deficit. We talked a little bit too about bilateral trade deficits, which is really what the reciprocal quote unquote tariffs are allegedly targeting. Even if you have no aggregate trade deficit, you will still, almost always have bilateral deficits with certain countries just because of how comparative advantage works. A good example there is that every European Union country follows the same trade policy vis-a-vis the United States because trade policy is done at the union level, and yet we have trade deficits with some European Union member states and not with others. For example, we typically run a trade deficit with Germany and a trade surplus with the Netherlands. That doesn't have much to do with trade policy, and there's no sense in which we are reciprocating tariff or non-tariff barriers against those countries with the tariffs we've imposed. You can just have bilateral deficits with certain countries, because they are particularly productive in relative terms in certain areas that and other, while other countries are not. And so I think both aggregate and bilateral trade deficits are just not, concerning. They're not a threat. Um, Also, of course, as Scott noted, they are not unique or extraordinary in the sense that we've been running them for a long time. Any given year, tons of countries run them. And the US has historically also run large trade deficits for extended periods of time. And so neither a threat nor extraordinary.
Hmm. Do others think that tariffs would reduce the trade deficit or have thoughts on that? Or not?
I mean, the clearest case in point is what we've seen this year so far, which is that we've dramatically ramped up our tariffs and we've not seen the trade deficit
Yeah.
go.
Yeah, and the standard reasoning is that because, a tax on imports is a tax on exports, basically. So you can use tariffs to reduce imports, but you're more than likely, due to various factors, raising manufacturers' costs, currency fluctuation, the rest, you're more than likely going to reduce your exports too. So your deficit remains basically in the same place, even though the numbers have changed on the export and import side. And I think it was the Dallas Fed just had a brand new study on this, and they looked at all these different countries with various tariff levels, and they found basically no relationship between tariffs and trade balances, right? So if you look at the scatter plot, it's just all over the place. And so that's generally the view. You can do a little bit on the margins, but the bulk of the trade balance has actually very little to do with trade policy and tariffs, and that's actually one of the big challenges we trade wonks deal with perpetually, is trying to explain that very basic fact.
And you can move bilateral trade deficits around, right? I think that's where people's intuition fails a little bit. Like, for example, the tariffs on imports from China that the first Trump administration imposed and that the Biden administration kept in place, those reduced our bilateral trade deficit with China. But at the same time, we saw our bilateral trade deficits with a number of other countries increase in a manner that, in fact, let our aggregate trade deficit to be greater than it was before.
Mm-hmm.
And just like one more sentence on unusual and extraordinary, like if you think about how IEEPA has been applied in the past, it was like in the aftermath of September 11th to come up with a way in which to make sure that dollars weren't flowing into known terrorist organizations, like in the face of an exigent national security moment. The idea that we're talking about trade, even if you could come up with some framework, which none of us are being able to articulate for you, because in fact, economists who think a lot about trade issues aren't going to articulate any concern about trade deficits being somehow some sort of extraordinary foreign threat. But even if you could articulate that, the idea that somehow the same authority that you deploy at point in time moments when there actually is an emergency that is newly emergent ahead of you is an authority that's at all relevant in the context of these relationships that have been decades long and move up and move down. It's just like a hard conceptual argument to make for IEEPA particularly.
Yeah, the government tries to get around that by saying that we are now at a tipping point. But of course, you can always say that. That's not, there's no substance to that. Yeah.
And, I think, though, this also gets to a big reason why this case is so important beyond just, the narrow tariff and economic arguments. I mean, if you can say that a persistent 30-year plus trade deficit is an emergency necessitating a unilateral tax on $3 trillion plus in commerce, all bets are off, right? I mean, what else, what isn't a threat? What can't the president do with this mechanism, whether it's tariffs or capital controls or whatever? And I think that's, we can all battle the economic and policy arguments on whether tariffs are good or bad and whether they affect trade balances. But there is, I think, a big, more fundamental issue with presidential power that this case raises, that of course we at Cato are extremely concerned about and been screaming about, in terms of executive power for decades. And it is a bit of our Super Bowl in that regard.
Peter, you had an interesting comment leading up to this about the implications if the court does uphold IEEPA tariffs. That's kind of an interesting thought to pursue. What do you think would be, the natural sort of consequences of that?
No, thanks. And I was actually going to jump in to make this point after hearing, Scott's comment just there about the importance of this for presidential power, because I do think this is an incredibly important case, not just for does the president have an effectively unbounded power to impose tariffs on imports of goods, but to what is the president's power to regulate America's connection to the international economy writ large. But before I get to that, I do want to make actually one comment pushing back a little bit on the this question of kind of an unusual and extraordinary threat. Now, I very much agree on any sort of plain language basis. The trade deficit is not unusual. In fact, we have run a consecutive trade deficit every single year since 1976, which was a year before Congress passed IEEPA. So it's very, very hard on any plain language to say, well, this thing we've had perpetually since before Congress passed IEEPA is unusual. That said, to the governments, maybe a little bit where I do think the government has a point here. Presidents have used or maybe misused IEEPA in lots of ways before we got President Trump. It's been used maybe 60 or 70 different times, everything from Iran sanctions perpetually in place since 1979 to fighting human rights, to fighting cybercrime, to fighting the risk of Chinese, telecommunications infrastructure being used to spy on Americans. So like the government does have this sort of practice, this record they can point to of, well, this has been used for lots and lots of things. And in lots of different ways, some of which do not seem particularly unusual nor extraordinary. And that is why I think that the court, I think like my co-panelists, I think the court will make the decision here on whether the word in IEEPA, regulate ... importation or exportation, includes the power to tariff. Because IEEPA does not explicitly reference a tariff or a duty or an excise or anything. It says government has the power to regulate importation or exportation of property. And the government's argument is that, a tariff is a form of regulation of that importation or exportation of property. But if you buy the government's argument here that regulate includes a power to tariff, there's no reason to think the IEEPA power to tariff would just apply to imports of goods, right? It applies to any importation or exportation of property. So, the president has said, in fact, in the legal filings, they've said they think it is bad for the United States that there are $28 trillion of foreign investment in the United States because there's like the net capital position is bad. Are they going to start taxing foreign investment in the United States? Maybe they don't want Americans to invest abroad. Are they going to start taxing American investment abroad? Because once you've sort of opened the door to this IEEPA power to regulate means a power to tax, just any plain language of the reading of the statute would suggest you could tax anything coming in or out of the United States. And also IEEPA doesn't just apply to what you think of as sort of goods and capital forms of property. It applies to intellectual property. It's been defined to apply to services. Could they tax, software exports from the U.S. because that's a regulation of the export of a service. And so I think we got to really think through here just how unbounded the president's power, not just on tariffs, but on all forms of international transactions could be if the court actually endorses the government's read of the statute.
Yeah, I'll note that some of those things you've definitely seen movement toward already in the one big beautiful bill in the initial draft. You had a Section 899 that would have introduced very significant sort of 5 to 20% taxes on the returns to investment earned in the United States by foreign investors from certain countries that follow tax policies that the United States doesn't like. That was removed in the final version of the bill, but the fact that it was there, at least in the draft, I think hints at ambitions along those lines. somewhat similarly, and this a version of this did end up in the final version of the bill. There was a tax on remittances on money sent abroad, not in exchange for services or goods. And so I agree with Peter. There's definitely a risk that these restrictions that are now sort of seemingly limited to trading goods would extend further to international capital flows as well.
Very interesting. Great. We'll start taking a few audience questions. If you'd like to put it in the Q&A, I can integrate some of those into our conversation. So there are just a few informational questions, actually. One asks, was there ever previously an opportunity to challenge the tariffs through an injunction rather than having to wait now that they have already been in effect? So I sort of remember the history of that, but I don't know if someone wants to take that, Scott, maybe.
Well, the Court of International Trade, so the lowest court that's heard these cases, actually did for a brief 20-hour period, I think, enjoin the tariffs. So that moved about as quickly as you can get in these cases, because that was back in May. I remember because I was on vacation, of course, when it happened, and so it's the Court of Appeals for the Federal Circuit, however, removed that injunction and allowed the tariffs to continue to be collected. So it did happen, but then it stopped.
I mean, it was stayed, right?
Yeah.
It is the remedy that they imposed. Then I think the Federal Circuit Court of Appeals said, because of the Trump v. Casa case that happened in between, said that's actually not the remedy we're going to be able to pursue here. But so it was still there. It was just stayed.
Yeah, exactly.
Interesting. I feel like it's an interesting sort of commentary about a broader theme here, which is like something we've been witnessing over the course of the last 9+ months now, is the fact that the judicial system is inherently like slow relative to the executive. And so there's like deep irony here, because if you read the government's brief in this case, part of what they're saying is now that these tariffs have been in place, it would be insanity, chaos, all the stuff to have to like reverse course. But of course, like they sprinted ahead of the judicial system, and in part are now making the argument that because they've sprinted ahead, it would be chaos to undo. And so there is something very fraught about the speed by which the executive is able to move relative to the judiciary.
Yeah, and I think it also gets to the uniqueness of IEEPA as a policy tool. A small nugget of truth in the administration's arguments is that IEEPA is a bit special. It's a tariff switch in the Oval Office, and President Trump has and can kind of flip it on and off until the courts say otherwise. And there really isn't another trade policy mechanism that allows for that sort of action. Even something like Section 232 is extremely broad. Section 301 also quite broad. There's a procedural process. You got to have an investigation and a report, and you got to check some boxes that slow things down a bit. With IEEPA, there's really no. You declare the emergency, you impose the tariffs, and then let the courts figure it out later, which, of course, as an economic matter, raises all sorts of issues. Policy uncertainty has skyrocketed over the last 6-7 months, and that's in large part due to IEEPA. But then the other thing is that for companies, I interviewed one of the litigants in this case a while back, and he talked about how in January they had planned for a certain amount of tariffs on imports of their products, and then overnight the tariffs quadrupled on what they had planned. There was no notice and comment. There was no process. There was nothing. It just boom, suddenly they're paying hundreds of thousands of extra dollars. And that's again unique to IEEPA, and I think also why IEEPA is uniquely dangerous.
Mm-hmm. We also had a question, when do you expect the SCOTUS ruling to land before year end?
Yeah, I think so. Read the oral arguments the first week of November. Counsel for one of the plaintiffs told me that they expected a decision before Thanksgiving, but otherwise I assume it will be almost immediately after.
Yeah, I'd heard early December, but yeah, hopefully as soon as possible.
I guess the way I'd look at this is I agree. I certainly think that if we're going to get a ruling against the tariffs, it's going to come quite quickly. I think that if we get kind of into the spring and there's no ruling, that's a pretty strong signal that it's going to uphold the tariffs.
Mm-hmm.
The later it decides, the greater the fiscal impulse too.
Exactly.
Mm-hmm. Right. So yeah, let's talk about what if the court does not uphold these tariffs? Can you talk a bit about whether there would be refunding for companies of the tariffs and what that would look like?
So I've heard, I'm
Well,
sure Scott and Stan are deep in this, as is Peter, but I've heard like many versions of the answer to that question.
yeah.
So one thing I've heard is that one way to kind of limit the scope of the sort of fallout is going to be to restrict the pool of people who can have access to these refunds to those who are parties to the litigation. Another thing I've heard is that they're going to hold out sort of and require affirmatively rather than just doing, we're going to take these refunds broad based and pay them back to the importers who have paid them. You could say that you have to apply affirmatively in order to get your refund, and you're starting to see people try to figure out like how would one do that if they wanted to. One thing that strikes me about incidents as an economist that feels important as we talk about the possibility of refunds in this space is that if you're dealing with tariffs that at least in some part have been passed through to consumers in the form of higher prices, the refund doesn't undo that fact, right? So we've done this like sort of perverse thing where we're actually making the importers better off vis-a-vis the consumers as a result of this reversion, even if we do figure out how to revert tariffs to all who have paid them.
And that which may explain why the estimates that exist so far show that the relatively large share of the incidents has been on American firms as opposed to American consumers, right? If there's a 50% chance you'll get a refund, I think your response is different.
Totally. That's actually a very good point.
As a just a kind of sheer observer kind of interest, it's going to be fascinating if you see how companies react to getting this sort of tariff refund windfall. Do they just, absorb it? Do some have, tariff-free sales? That'll be kind of fascinating. On the refund side, though, I mean, I think the easiest way to think about it is there's kind of an easy way and a really, really hard way. The courts could make it pretty easy if they wanted to, because there was an old case involving a harbor maintenance tax going a long way back that was ruled unconstitutional. And effectively, the courts did a kind of a blanket refund where all importers had to do was file a protest and they could get their money back. So you didn't have to file a lawsuit. And the reasons the courts did that was that it would be just administratively brutal to have hundreds and hundreds of lawsuits and all of that. There's an even easier way that's happened with the refund of duties collected under the generalized system of preferences, which is this preference program that expired a few times, and then Congress reauthorized it retroactively and let everybody get their money back. And in that case, Customs literally just pushed a button and refunded into everybody's bank accounts the duties that have been collected, because all of these imports have little numbers attached to them. And so in theory, it could be as easy as pushing a button. In reality, my guess is that this is going to end up being subject to its own litigation. That it's going to end up down back at the lower courts. I wish it didn't, but I think it is going to end up back there. And you're going to see a lot of fighting about this because, you are talking about tens of billions of dollars in duties collected. I mean, it's about 30 billion a month we're running right now per the Treasury. That's a lot of money, and everybody's going to fight over it.
Just to add on to Scott's comment there, I mean, and if you take the government's filings here at face value, the president certainly believes the government can't give the money back, even if they are legally obliged to give the money back. And so I do think there's a chance, especially if the courts do not mandate an administrative process. I think the government will then probably take the position of, well, if you want your money back, you got to come in and sue. And then I think there's going to be a really interesting sociological question for companies, because I could easily see President Trump going out and saying, and if you sue me over these tariffs back, you're dead to my administration. And that's really going to, there could potentially be some political costs to companies trying to get their money back here, even if I think from a legal perspective, they should very clearly be entitled to their money back.
Mm-hmm. We have a reader question here, or sorry, a watcher question, I suppose. I'm used to reader questions. In the event that the tariffs are allowed by SCOTUS, are there any efforts to make them more permanent? If not, will tariff policy flap in the wind with each new administration? And he says businesses certainly aren't going to move supply chains if they believe the tariffs could fall with the next president. Yeah, any views on that?
So I think that's a deep insight and an important one. I mean, it's funny, I'm teaching federal income tax. And one of the sort of points in broad tax policy is that there is just inherently a fair bit of a cool thing about teaching tax is that it's dynamic in that every few years you get big tax reform and the tax code changes pretty meaningfully, it feels like. And tariffs are actually, especially in the way in which, as Scott is describing, you almost have like an on off switch in the Oval Office if IEEPA is deployed in this particular way. They're even more subject to that kind of volatility, of course, because at least the way in which these powers are being used at the moment, sort of needing to have legislation that runs through Congress isn't actually necessary to effectuate these giant changes. Instead, you're doing it directly through executive power. And so if I were a business that was looking at tariff rates that are currently at their highest level since 1934, and I'm trying to project out to what's going to happen in 2028 or 2032, I think you have to think that this is a sort of a lever that is going to get pulled in future administrations, and trying to game out with any sense of stability about what the world is going to look like is incredibly, incredibly challenging, and obviously going to have behavioral effects for the firms that are trying to adjust.
I would be surprised if Congress were to make the tariffs permanent through legislation, in part because I think something the current administration really likes is that they control the lever. Whereas if you were to make them permanent, you wouldn't have that ability. Of course, somewhat counter to that runs the fact that Congress would be able to use tariff revenue if they enacted it to offset maybe other. If they pretended that the current tariffs are temporary, they could say, okay, we're going to enact them and offset some other tax cuts or spending. Though, all of that offset logic is all, pretty fake. So I don't know how strong that argument will weigh. Yeah.
Are there any other thoughts on what the role of Congress should be right now, or where this could lead in the longer run? That we haven't touched too much on that.
Yeah, I'd like to start since this is a drum we've been beating for a decade now. The reality is that it's not just IEEPA. If you look at U.S. trade law, there are a half dozen statutes that have been passed by Congress over the last 80 years under this assumption that the president was going to be the least likely to abuse these laws, the most responsible, probably the least protectionist member of the government, and that the president can be trusted with these vague terms like national security and other things. And thus, who cares about the details of these laws? Who cares, about the procedures? We can trust the president. Trump has imploded that whole assumption that really undergirded U.S. trade policy since about the 1930s. And there is a huge role for Congress, if not to actually pull back on the president's power. That's what I would like to see. But if only to simply provide more precision on the process and the terms here. Because right now, whether it's an IEEPA, Section 301, Section 232, and on, there's, Section 122, which we haven't seen yet, Section 338, which is another one that's just kind of hanging out there. These things are just, they're not just a policy problem, but they're a bit of an economic problem because as market participants, especially after what Trump has done, you just kind of don't know what your trading investment environment is going to be. As Natasha and Stan mentioned, the next president could change policy at the drop of a hat. And so there's a need just to simply get in there and fix these laws, reform these laws to provide a little more predictability and consistency. The sad reality is that there have been multiple proposals, legislation has been introduced repeatedly by Republicans and Democrats. There's several bills out there right now. There's also been legislation proposed to reform the National Emergencies Act, which almost passed until Trump won, and then suddenly Republicans got disinterested in that. And so there's a lot for Congress to do in this space. The sad question is whether they'll actually do anything. And unfortunately, there doesn't appear to be a ton of broad bipartisan interest. There's a nice little cohort of, say, 30 senators and 100 representatives, but getting to those, veto-proof thresholds, that's the real challenge.
Mm-hmm. There are a lot of questions in here about the other alternatives the Trump administration can pursue. So, Scott, earlier you did mention the 232s that are being set up. You threw out a few numbers right now. All these numbers: 122, 338, 301, right?
Sorry.
No, that's okay. No,
those and the acronyms. It's a disaster for a trade.
Right. So these
and
are
it's not even sections of the same statute.
Yeah.
Right. These are sections of various trade laws, right? Where Congress has delegated certain tariff authority to the president in more bounded ways, maybe. There are questions about, are we risking a whack-a-mole situation with tariffs when we just see the administration use these other authorities? Would they use 122 to put a 15% floor back in place for the reciprocal tariffs, and then 301 and 338 to replace country-specific rates? I also think this question is really interesting. With this broad use of Section 232, is it likely that Section 232 would be challenged in court next? Do you want to weigh in on some of those alternatives?
Before Scott goes, Scott, maybe I will note that one sense in which we are not playing whack-a-mole is that you cannot use these tools to retroactively tax imports, right? So to the extent that there'll be a broad refund, that's going to be over 100 billion in tax revenue that the administration will not be able to replace with these other tools. And so I do think that's important to keep in mind.
Yeah. And I think that there would be future challenges to the use of some of these other laws. Section 232 seems to be the least likely to be challenged because there has already been so much litigation on this. That said, what the administration is now doing by expanding these tariffs to cover what they call derivatives, but includes all sorts of things that have only a small nexus with the underlying investigation in case, like cans of whipped cream are now being covered by steel tariffs, right? So there's a chance for some litigation there, but I think that 232, and I think the administration thinks 232 is going to be a big vehicle for pulling in a lot of the stuff. The Section 338 one, I think that would get litigated. So I think that's another big point. Some of these laws are untested, and I think there would be a lot of future litigation surrounding their use. Regardless, though, they all have more limits than IEEPA. I mean, even 338, which is just really short, you have to have a discrimination involved, and that limits it beyond what IEEPA is. And so, even though I think there are going to be expansions in other tariffs should the IEEPA tariffs get invalidated, there is a benefit beyond what Stan said, beyond the additional litigation, that all of these laws, even though they need to be reformed, have more limits compared to IEEPA.
And not just, limits also, and Scott, and process, right? So
right.
Section 232, it's like, we can talk about the merits of these investigations, but it's an investigation and a report that goes from the Commerce Department to the president. So it's like, just there are more sort of, at least we'll see in actuality, but at least in concept, there is more room for there to be process rather than this like on-off switch as we've kind of been describing with IEEPA.
Yeah, even just getting a bit of a delay, right? So, there were just some new investigations announced that were apparently started September 2nd. We just found out about them. But that type of notice is valuable to market participants. So while I would love to see a lot of this stuff nuked by Congress, there are benefits to moving away from IEEPA regardless.
Okay.
Except for Section 122, which does not have those delays either, but of course has a lower maximum rate.
And it's time limited. So I think the administration could pull this fast one where when the 150-day time limit comes up, they just then start it again, right?
Exactly.
But I think that would then get litigated itself.
I see.
Interesting.
I see.
We have to wrap up pretty soon. Just to close, I'll ask what I'm curious what this would mean for the trade deals that various countries have negotiated. The administration has insisted that other countries would kind of still continue to honor them, but U.S. importers don't have to, right? And then we did have a audience member question about USMCA review, saying how would a Supreme Court decision in the middle of this renegotiation affect this? Do you think Canada and Mexico would drag their feet to see what happens? What is the rest of the world looking in on this likely to, how are they likely to respond?
I think the agreements we have so far are either marginal or, vague and, come with commitments that are unrealistic or ill-defined. We're already seeing South Korea pulling back from what the Trump administration alleges the agreement was. And so I don't think of that as a major negative consequence for the country or a major source of uncertainty, because there is so much uncertainty around what those agreements themselves mean. Of course, similar to USMCA, which apparently doesn't mean anything, and we can just impose tariffs on Mexico and Canada whenever we feel like it. But yeah, sorry, Peter, go ahead.
No, I was going to say, I think of this, I think of these trade agreements as having kind of two pieces, right? There is the U.S. tariff rate piece, and then there is the what the other countries have agreed to do piece of it. And obviously, while Trump believes that the tariffs are being paid by, the foreign governments or whatever, that's just not true. And so in the real world, what would happen under these agreements is, at least in the short run, the tariff piece of this would go away, right? The U.S. importer who's paying to import something from France no longer has to pay it. And so then the question is kind of, well, do the foreign governments, kind of continue to make motions towards honoring the commitments that they had made as a part of these agreements? And I guess I think they will probably continue to make motions towards honoring parts of them, because they have various reasons to do so. First of all, they think that, they understand Trump might be able to bring back some of the tariffs under other authorities. They also, as part of these deals, they haven't just gotten relief from the IEEPA tariffs. They've gotten relief from some of the higher rates of the 232 tariffs, right? So if you're Germany right now, one of your benefits from the deal with the European Union and Trump is that your car tariffs have fallen from 27.5% to 15%. So I think you sort of make some motions towards honoring. On the hard parts of the deals, like these investment funds or these, you probably don't rush to implement them, but you also don't walk away, and you kind of move things slowly while the U.S. side of this sorts itself out.
Also, because these trade agreements are, of course, in most cases, are tied up with America's security commitments to those countries, right? Through NATO, to Ukraine, to Japan, South Korea.
Mm-hmm. Great. All right. Well, I think we're about out of time for today. Thank you so much to our audience. Thank you to our panelists.
Thanks so much.
Thanks.
Great to be with you all.